Testing, testing.
Alrighty, welcome to the Public Service Commission's administrative meeting for January 8th, 2025. First item is to approve the minutes from our meeting of December 18, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Good morning, Chair. Today we have 4 items on the consent agenda. The first one is from TPE MDGA 137 LLC. Its request for extension of Community Solar Pilot Program operational deadline. Number 2 is Wakefield Solar Energy Center LLC, request for temporary extension and limited waiver of Community Solar Pilot Program operational deadline. Number 3 is from FiberLight LLC, its notice of participation in certain financing arrangements. And number 4 is Cox Virginia Telecom LLC, its application for authority to provide facilities-based local exchange telecommunication services in Maryland.
Okay, regarding item 1, I move we grant the waiver of the operational deadline for the GA 137 solar project until July 18, 2025. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 2, I move we grant the waiver of the operational deadline for the Wakefield solar project until March 18, 2025. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Item 3, I move we note the new financing. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And item 4, I move we note the filing with the understanding that the company, Cox Virginia Telecom LLC, will file a new application for operating authority if it seeks in the future to offer any services in Maryland over which the commission does have jurisdiction. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Today there are 7 items on the administrative agenda. Item number 5 is Major Energy Services LLC and Tomorrow Energy Corp. It's notice of assignment of customer contracts from Tomorrow Energy to Major Energy Services.
Good morning, Chair and Commissioners. Andrew Schlicht on the behalf of staff. On October 24th, 2024, Major Energy and Tomorrow Energy filed jointly with the Commission, providing notice of a transfer of their contracts from Tomorrow Energy to Major Energy. The filing entities also provided staff with a copy of the transfer notice that was provided to customers. Upon review of this letter, staff finds it satisfactory. In its analysis, staff did find numerous complaints filed against the receiving company, Major Energy. Staff inquired with the company about these complaints for additional information. Major Energy informed staff that the company has taken a number of steps to reduce the amount of complaints it receives. Staff notes that these efforts appear to have had an impact, as when staff consulted CAD for complaint information, no complaints have been filed against Major since November of 2023. Staff recommends the Commission note the filing and is available for questions.
So, any questions of staff? Commissioner Sushman.
Good morning. So I want to turn to your buck sheet, and this is page 3. And so this is the chart, and I'm finding this chart to be a little confusing. So is the complaint count total number of complaints?
This is the total amount of complaints against the gas and the electric operations for Major Energy.
Right. Okay. So but does the left, so the y-axis, is that total number of complaints? So when you're approaching 90, or I think it's 80, that's the total number of complaints from January 8 of 2018 to September, right? It's cumulative.
That is correct.
Okay. So so there were 80 complaints filed between January of 2018 and you said October of 2020.
November 2023.
Okay. So, and then no complaints have been filed since.
When staff queried CAD for complaint information back in December, November, at the time that this was being authored, we did not find any complaints since then.
Okay. Although I have to say that of approximately 80 complaints over a 5-year period seems like a lot of complaints. Was staff concerned about the number of complaints that were filed against this company that is about to take on additional customers?
Staff is always concerned about customer complaints. Staff takes complaints from customers quite seriously. Staff does also acknowledge that a number of these complaints were found in the company's favor, and the company has been taking steps to mitigate these the number of complaints that it receives. And the company was open with staff about what steps they're taking, and assured staff that they're going to continue with implementing these efforts for any new customers that it onboards.
No, I appreciate that. It's just that 80 seems like a lot. I mean, we've seen other filings come before us, 7, 8, 10, 80. I was just struck by the number, and I was reasonably certain that's where we were going. The 80. That just I'm just telling you that just seems like a lot. So I mean, when we get to sort of next steps, I just want to sort of express, Mr. Chair, that I am concerned about Major Energy taking on additional customers, and I think we need to be much more have eyes open in terms of the company moving forward, to make sure that we never put ourselves in this position on in terms of the ratepayers that are their customers. So, thank you.
Commissioner Barbe.
Yeah, thank you. I'm using my credit card to kind of line up the vertical lines here. So it appears that the complaints stopped somewhere between September of 23 and January of 24, right?
That is correct.
Okay. And it also appears that the spike occurred between somewhere like January 21 and May of 23. That's when the big ramp up occurred. What did you get any explanation for why that period was problematic? Maybe I should ask the company, but do you know?
I understand that is when the Major Energy was implementing its new approach to addressing complaints. Specifically, I cannot speak to.
Okay, I'll ask the company. Okay.
Okay. All right. So why don't we turn to OPC, since they filed a couple of sets of comments on this.
Good morning, Milan Tekle-Mikhail on behalf of the Maryland Office of People's Counsel. OPC makes the following recommendations due to concerns we have about the shuffling of customers between retail suppliers. Companies could potentially use the transfer of customers without explicitly, transferring the assigning company's obligation and liabilities in order to avoid responsibilities that might be owed to the transfer customers. OPC recommends, in noting Tomorrow Energy's assignments of contract to Major Energy, that the Commission require the following actions. First, to accept into the record the asset purchase agreement that OPC was able to obtain from Tomorrow Energy. In future instances, we ask the Commission to require such documentation be attached to the notice that companies file. These additional records are needed to make clear which entity, the seller or purchaser, retains the liabilities and obligations under the contracts that may stem from incidents that predate the transfer, including any violations of Maryland Consumer Protection Law that may later be brought to light. We also would like to note that the version of the purchase agreement we are asking to be entered into the record is the redacted version. Second, for Tomorrow Energy to keep its license active and maintain all of its existing bonds for a minimum of 3 years. Third, for Major Energy to file monthly reports for a period of 24 months describing any new complaints made by Major Energy customers, including those subject to these assignments, along with Major Energy plan course of resolution for those complaints for the stated reason, Commissioner Suchman, you mentioned, where, these customers are being transferred to a company that does have a problematic history in Maryland, and we need to keep record of how they're handling complaints and how they're handling this expansion of customers. And finally, for Tomorrow Energy, within 30 days to file a report with the Commission on the status of the complaints filed against Tomorrow Energy from January 2018 through November 2024. OPC makes these recommendations in light of both Tomorrow Energy and Major Energy having significant complaint history in Maryland, as demonstrated by the CAT complaint reporting chart and suspect sheet. As a consequence of this assignment, Major Energy's residential customer base will expand, potentially exposing transferred customers to issues stemming from the company's troubled history. But it might also leave some customers who have outstanding complaints against Tomorrow Energy with unclear recourse post-assignment of their contract to Major Energy. Enhanced reporting will permit the Commission to monitor the effects of the assignment and identify potential patterns of poor retail supplier performance earlier than on a quarterly basis. Having this complaint information available sooner than a quarterly basis could facilitate prompt actions to address the retail supplier performance and place additional protective measures in place for customers if necessary. These recommendations are in line with recent orders by the Commission concerning retail suppliers Energo Power and Gas and Constellation New Energy. As a condition of noting the assignment in that matter, the Commission ordered Constellation New Energy to provide quarterly reports covering all complaints filed with Constellation or the Commission's Consumer Affairs Division by any Constellation customers, including former Energo Power and Energy customers. They also, in addition, the Commission ordered Energo to maintain a bond in effect that covers liability to its former electric customers for a period of 3 years. So our recommendation is in line with Commission President, and so we ask that the Commission orders similarly in this matter. Thank you. And the purchase agreement is here if needed.
Any questions, Commissioner Barbe?
Yeah, thank you, Mr. Chairman. I saw in your what you sent us that the company sent you a link to their 10Q. Was that a sufficient response for you for the asset purchase agreement?
That's a great question. Not at all. It does put the burden of doing the work and going through the asset purchase agreement on OPC, but also it puts the burden of requesting that document from OPC and staff. To this day, I don't know if staff has this particular document and if they have reviewed it. So it kind of...
Well, let me ask this question. What precisely would you like them to report? Do you want them to do a report where they do what? Say who the purchaser was, who the seller was, what other elements do you want to have the company identify?
We would like the company to identify, as in this case, they mentioned sections 2.4 of the purchase agreement where the liabilities are retained for those customers that are being transferred and who holds that liability. In the previous case in Energo, that wasn't clear, and so it created confusion as to whether Energo or Constellation would maintain that liability, where in this case, it is within the purchase agreement, but we had to go ahead and seek that information out in order to make sure that there isn't a gap leaving customers, high and dry as to recourse. So we would like them to highlight that information, but we would also like this information to be in the record with the commission.
Now, did I hear you correctly a moment ago? Did you say that this requirement for a purchase agreement should just be the standard requirement that we have for all other deals? Or did I mishear you?
I think in the instance of assignment of contracts, it would be beneficial for the commission to have access to that information.
So
I mean,
you
the
want us to
commission-
do that in all instances?
That would be beneficial.
Okay,
yes.
that's what I thought I heard you say. Okay, thank you very much.
Any? Okay, so let me turn to the applicants.
Good morning, Chairman Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of Major Energy. Tomorrow Energy is represented by Max Cook behind me, so if you have questions for them, he's available to speak as well. We appreciate staff's review of this matter and their comments in the buck sheet. And certainly happy to answer any questions that commissioners may have about staff's comments. With regard to OPC's recommendations in this matter, Major Energy, I think as staff indicated, there was a kind of a rise in complaints a few years ago. My understanding is that was driven by kind of sales and marketing activity up front and some issues that came about during that phase of the process. I think that the recent complaint record over the last year and a couple of months shows that that they've taken affirmative steps that have addressed those issues. Going forward, for a little bit of context, my understanding is that this group of Maryland customers that were assigned pursuant to this notice and this transaction is a small piece of a much broader transaction that involves customers across 7 states. So it's not a Maryland-specific action. And, I think Major doesn't see a need for additional complaint reporting. We certainly understand Commissioner Suchman's concerns about the rise that occurred over the last few years. But we think that the record reflects that the steps Major has taken has addressed the issues that led to those complaints. If the commission is inclined to impose a reporting requirement here, Major would recommend that the commission do a quarterly report. I think having separate monthly, a 30-day report and then separate monthly reports for a supplier that is shown, a good trend in going to 0 complaints over the last year is duplicative. But we could do, if we could do quarterly reporting, we'd be happy to keep the commission apprised of any complaints that do come in. We don't anticipate that as a result of this transaction, right? These are customers that are already enrolled, and they'll just continue to be served by Major pursuant to their contract. So with that, happy to answer any questions that the commissioners may have.
Questions? Commissioner Sussman.
I worry actually from staffing perspective of monthly reports. I'm not so concerned about your client because assuming there are no complaints, which is what I'm hoping that's the case, the reporting will be 0. I worry about sort of overwhelming our staff. So I'm okay with a quarterly report, but I would like to actually include in that report any complaints filed by the transferred customer, because they're moving from one company to the other to another company, and I want to make sure that is a seamless move. And so, to the extent that there are issues, we need to know about them. But I think this quarterly reporting needs to go on for several years, because it's this for whatever reason there were a lot of complaints. There were a lot of complaints, and I don't think we can ignore that. And SB1, some of the reason why you're seeing SB1 and we're seeing SB1 is because of this. And so we don't want to be in a situation where we're going to have additional problems. So, Mr. Chair, I'm okay with quarterly, but I want to have it be a robust quarterly reporting. And if there are any complaints, we're going to be taking those complaints very seriously.
Okay, Commissioner Barve.
Thank you, Mr. Chairman. So just to make it very clear, It appears that there have been no complaints since September of 23, roughly. Is that what you're saying?
That's my understanding.
And all the complaints that had existed have been resolved?
I don't know the status of all of the complaints. I mean, given how long it's been, and the efforts that,
Okay.
the CAD process, has been ongoing.
Well, in that case, Mr. Chairman, can I ask our staff, because I think in the buck sheet it said that the complaints had been closed. By that you mean they've all been resolved?
That is my understanding at this point.
Okay, thank you. Thank you, Mr. Chairman.
Sir, Richard?
Yeah, I just wanted to also just inquire about the company's position on the bonding requirement to extend that. Did I understand correctly that you're okay with that recommendation?
Yeah, if I may defer to Tomorrow Energy, because I think that was specific to
Yes.
them. I'll step aside.
Morning, Mr. Chairman and Commissioners. Max Cook on behalf of Tomorrow Energy Corp. Yes, the company has reviewed staff and OPC's filings and appreciate their comments. Tomorrow Energy will continue to maintain its license and the bonding in place for that 3-year period as recommended by OPC.
Okay, terrific. And just, I think Commissioner Suchman covered it well, but is there any kind of a narrative you can provide as to why there was this sudden bump in complaints? And I would just note that was during the period when this commission had implemented its maximum enforcement. We had been made aware of a lot of difficult, problems out there, and it just seems like it. And it was also the same time, really, period when the legislature started taking some action and considering legislation. So, are you able to provide any insight? What happened? What was there a breakdown? How did they become so tone deaf, I guess, to the situation here in Maryland and what we were doing?
Yeah, and this might be best answered by staff or Mr. Wallace, but I can say that based on some of the filings, it appears that it was with respect to marketing and the signing up of customers, and I can at least say that since then, I believe that the group doing the marketing was no longer working with these companies, as indicated in, I believe, staff's buck sheet.
Okay. All right. Well, again, I share all of Commission's concerns about these violations, but I'm particularly concerned when they happened. It just seemed like it was almost a finger in the eye to the Commission at that point, considering what we were doing and trying to tamp down these violations. So I don't. Do you have anything to add to that?
Yeah, certainly understand the concern. My understanding is similar to what Mr. Cook just laid out, that there was a kind of sales and marketing push, bringing on some new vendors that were doing that at the time, and there were problems, and that led to complaints, and they took action to, remove the folks that were leading to those complaints. But at that point, it's too late. You've already got the spike in complaints, and I believe there were some meetings with CAD proactively to talk through what they were doing about it, because there was the maximum enforcement period that was going on, and there was an effort to really stem that tide, and it looks like those efforts worked. But I certainly recognize the concerning trajectory that was happening at the time.
Great. Well, thank you, Mr. Chair. And I also just support OPC's suggestions, but I'm also good with the suggestion that Commissioner Suchman that we change that to a quarterly report.
Okay, so I think what we're going to do is actually take this under advisement, since there's a couple of moving parts with this. But, you can be assured that the order we issue is going to require some sort of reporting. But I want to be a little more specific about what exactly is going to be in the report. I do think the report will be quarterly, not monthly. But I want to be a little specific about what we want out of you, and then also incorporate these other two recommendations from OPC that you're apparently okay with. So we'll get something out on that, but the substance of the filing will be fine. So.
The next item on the agenda is also from Major Energy Electric Services and Tomorrow Energy Corp. It's notice of the transfer of ownership for the customer contracts of Tomorrow Energy Corp to Major Energy Electric Services, LLC.
Good morning, Chair and Commissioners. Andrew Schlicht on the behalf of staff. On October 24th, 2024, Major Energy and Tomorrow Energy filed jointly providing a notice of transfer of customers from Tomorrow Energy to Major Energy. The Staff notes that several complaints had been filed against Major Energy, and staff recommends the commission note the filing and is available for questions.
Okay. And OPC, I take it this is the same recommendation you want to make on?
Yes, Commissioner.
Right,
Same
okay.
recommendation.
And I take it from the two applicants, basically the same position, correct? All right, so we're going to do the same thing with this one that we did with the electricity license. So we'll be issuing something on both of them, so.
Sorry, Commissioner, by any chance, would you consider us entering into the record the purchase agreement? Or should we request that the company submit that themselves?
What do you, I mean, does the company have any thought on that or any problem with that, I guess?
We don't have a problem with that. The agreement was part of a public SEC filing.
see.
So, the commission could take judicial notice of that public filing, or OPC could file it, or we could file it.
Staff have any thought about this one way or the other?
Staff does not object to the purchase agreement being filed.
Okay, go ahead and file it, so, yeah, thanks.
The next item on today's agenda is from Maryland Water Service, Inc. It's response to Commission directive and revised tariff pages reflecting the rates set forth in the errata proposed order.
Good morning, Chair and Commissioners. Alden Manka on behalf of staff. On December 2nd, 2024, Maryland Water Service, Inc. filed revised tariff pages to update its tariff in response to the Commission's letter order mail log 313830 in case number 9729. On December 30th, 2024, the Commission issued order number 91462, accepting the Public Utility Law Judge's proposed order issued on October 21st, 2024. This filing establishes the new distribution rates that will allow the company to collect an incremental revenue increase of $1,304,012 as approved by the proposed order. Staff has reviewed the filing and concludes that the proposed tariff rates are in compliance with the order. Residential customers are estimated to receive an average bill increase of between 17% and 51%, depending on which water system the customer resides in, with the lowest average increase being for the Highland Estates customers and the highest average increase being for Green Ridge customers. Staff recommends the Commission accept the tariff for filing with rates effective for all bills rendered on or after December 2nd, 2024. Thank you, and I am available for questions.
Any questions?
Thank you, Chair Hoover, Commissioners. David Beaglemans on behalf of Maryland Water Service. I'll keep this short. We support staff's recommendation, and I'm here to answer any questions you may have. Thank you.
So just refresh my memory, the comment he made about the rate impacts on the various sub-companies, where are they located?
Sure. The companies or the individual systems associated with this company are dispersed across the state. So the company has two systems in Harford County, one system in Anne Arundel, and two systems in Allegheny County.
Okay. And in your comments, you mentioned two specific parts of the rate increase applying to two of those companies. Which ones were they?
The lowest increase is for Highland Estates, and the highest is for Green Ridge.
And where are they?
Highland Estates is in Allegheny, and Green Ridge is Harford.
Okay. All right. Okay. Any questions? All right. With that, I move we accept the tariff pages for filing with rates effective for all bills rendered on or after December 2nd, 2024. Commissioner Sussman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
The next item on today's agenda is from Maryland American Water Company. Its application to issue up to $12 million in long-term bonds.
Good morning, Mr. Chairman and Commissioners. Cameron Walton on behalf of staff, and I'm joined by Barbara Weber of the Engineering Division. On October 16, 2024, the Maryland American Water Company, MAW, filed an application for authority to issue up to $12 million in long-term debt by December 31st, 2026. The funds may be raised through loans from its affiliate, American Water Capital Corp., AWCC, and/or low-interest financing from the Maryland Department of Environment and the Drinking Water State Revolving Fund, DWSRF. MAW provides water services to approximately 5,070 customers in Bel Air, Maryland, and following its acquisition of Severn Water Company, this base will increase by 1,702 customers. The proposed issuance will be used for the repayment of short-term debt as well as the construction, completion, extension, or improvement of the facilities detailed in Exhibit 4 of the company filing. Under Public Utilities Articles, Section 6101A2 and 6102B, a public service company that operates in Maryland may not, without prior commission authorization, issue debt that is payable wholly or partly more than 12 months after the date issued. The information in the application and in MAW's responses to questions posed by staff regarding the anticipated use of the funds raised by the proposed debt issuance satisfies the standards in the Code of Maryland Regulations, COMAR, and the Public Utilities Articles and Annotated Code of Maryland. The Engineering Division staff has performed a review of the projects in the company's 2025 to 2027 capital plan. Utilizing the company's responses to staff data requests and company's Exhibit 4 project list, while it is possible that the projects listed may be found acceptable and necessary to maintain the integrity, reliability, and safety of MAW's water system, staff is uncertain regarding the justifications for some of the listed system upgrades and safety improvements. Accordingly, the Engineering Division staff recommends that the company may be required to meet with staff quarterly regarding its capital project plans to ensure staff has a thorough understanding of the company's capital project plans. Staff recommends that the Commission approve Maryland American Water's application to issue up to $12 million in long-term bonds. Additionally, staff recommends that the company be required to meet with staff quarterly regarding its capital plans. Thank you, and I'm available for any questions.
Any questions? Okay.
Thank you, Chair Hoover. Commissioners, David Bugelmans, this time on behalf of Maryland American Water Company. I'm also joined this morning by Ms. Anna Kazasi, the Director of Engineering for Maryland American. We appreciate staff's review. We do not oppose staff's recommendation today, including the quarterly meeting. Otherwise, we're here to answer any questions from the bench. Thank you.
Any questions? Well, actually, so I have some. I mean, I know from past experience that this company's had some challenges with their distribution systems with some of the companies, I guess the Allegheny ones, just because of the topography and whatnot. So have you made decisions about where exactly you're going to be doing the work that's going to get financed by this?
Sure. This company operates systems in Harford County, in Bel Air, and now in Anne Arundel. But this is a different company, Chair, than
Okay.
Maryland. I'm happy to answer questions about Maryland Water.
No, that's fine. Okay, it's my mistake. But have you figured out exactly where you're going to be doing various projects, or?
Sure. I think for that, Anna, do you want to
Sure.
provide an overview of some of the?
Good morning. We have a list of projects that will take place in Bel Air and as well as Severn. I could provide a brief overview if you would like. They are in Appendix 4. Exhibit 4, I'm sorry.
Well, I guess I don't want to get too far down the rabbit hole on this one. But these are essentially just, basic infrastructure improvements to the
Yes.
overall system.
Yes, distribution and production.
Okay, all right. Okay, I think I'm fine with that then. All right, so I move we approve the company's application to issue up to $12 million in long-term bonds and direct the company to meet with staff on a quarterly basis regarding the capital project plans. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
The next item on today's agenda is from Hopskip Drive, Inc. Its request for waiver application under Public Utilities Article Section 10-104E.
Good morning, Chair, and good morning, Commissioners. My name is Scott Roper. I'm with the Transportation Division from staff. On December 28th, 2023, Hopskip Drive requested that the Commission grant Hopskip Drive a waiver pursuant to Public Utilities Article 10404E the requirement to conduct fingerprint-based background checks of Hopskip Drive's for-hire drivers. The company then amended this request on December 3rd, 2024. The staff has reviewed the request and series of data requests, and we recommend that, one, the commission grant Hopskip Drive a waiver of the fingerprint-based background check required by Public Utilities Article 10-104B, approve an alternative background check process for the company as specified in staff comments and accompanying exhibits to be used in lieu of PUA 10-104B fingerprint-based background checks, require the company to comply with all the requirements imposed by the commission in order 87957, granting a similar waiver to Lyft and Razor, which does business as Uber, and to require the company to notify the commission within 10 business days of the issuance of the waiver, whether the company accepts all the conditions imposed by the commission in connection with this waiver.
Any questions of staff? Okay, so I guess OPC, since you filed comments, go ahead.
Good morning, Mr. Chairman and Commissioners. Nicole Zeichner on behalf of the Maryland Office of People's Counsel. OPC originally filed comments in this matter on Monday, and we had raised concerns with two specific aspects of Hopskip Drive's complaints, or I'm sorry, applications. And the first was that it did not appear that they would be following a fingerprinting requirement because it was not included in the affidavit of Mr. Williams that was filed with staff's comments. And the second was that we wanted to see something that would be comparable to Maryland's process for continued criminal, or essentially real-time criminal record monitoring. The company has since filed an updated affidavit yesterday, and OPC did file a letter stating that we withdraw our concerns. So at this point, we do not have concerns if the commission approves and orders the process described in yesterday's affidavit. But I'm available for any questions. Thank you.
Okay, any questions? All right, so let me hear from the company. So.
Thank you, Mr. Chair and Commission members. Nicole Hampton. I'm the Director of Regulatory Affairs for Hopskip Drive and oversee our compliance with fingerprinting and background check requirements across the country and all 14 markets in states where we operate. We have appreciate the diligent work of staff over the last year to understand our operations and how Hopskip Drive has proposed an adequate and consistent alternative in requesting the waiver of these requirements. I do think it's important to point out to the Commission and just clarify once again, Hopskip Drive is a transportation network company. We are designed and built to arrange transportation for individuals who need extra care, which is generally minors. And so we generally are doing that through contracts directly with school systems, nonprofit agencies, and government agencies who have a need to arrange specialty transportation for some portions of their population. As a result of that, we don't disagree that it's important and necessary that these drivers be fingerprinted. This waiver is simply in an effort to ensure that drivers don't have to be fingerprinted twice. Many times these school districts or government agencies have their own process that has to be followed for state and FBI databases to be checked. And in the event that that is happening, we believe those drivers should not have to be fingerprinted a second time. And go through the traditional PSC process that's contemplated by the code in those instances. In instances where we do not have a client who is requiring to own that process themselves, as contemplated in the affidavit from Mr. Wright yesterday, and as has been discussed with staff, those individuals would still be fingerprinted through the traditional TNO process. So I'm happy to answer any questions the Commission has.
So, Commissioner Sussman.
So just to be clear, any driver that works for your company will be fingerprinted. The concern was that you would be fingerprinting twice in order to meet the requirements of the commission.
That's correct.
Okay. So, and OPC, that's your understanding as well? Okay. Thank you.
Okay, and I guess just one question for me. So the reason for this is because of the sort of specialized nature of their transportation business as opposed to the other folks that you regulate?
Yes, so the statute does allow a fingerprint waiver for transportation network companies such as Uber and Lyft, for example, of which Hopskip Drive falls under this model. In their particular case, because they're doing with school-age children, they're fingerprinting all their drivers anyway as part of those contracts. So they're essentially just asking for a waiver of what would be duplicative to what they're already doing to do through us.
And I guess just as a follow-up to Commissioner Suchman's question, so one way or the other, all of your drivers are going to be fingerprinted by somebody, either because of the school system requires it or because we require it. So there's nobody's going to fall through the cracks, right?
That's correct, Mr. Chairman. We follow that company policy in every market where we operate, and actually just advocated successfully for the California PUC to implement fingerprint requirements for Uber Teen for this exact purpose.
Okay. Anybody else? Okay. All right, with that, I move we grant the company a waiver of the fingerprint-based background check required by Public Utilities Article 10-104B. Approve the alternative background check process for the company as specified in staff's comments dated January 2nd, 2025, and accompanying exhibits to be used in lieu of the Public Utility Article 10-104B fingerprint-based background check. Direct the company to comply with all of the requirements imposed by the Commission in Order Number 87957 in granting a similar waiver to Lyft Inc. and Razor LLC. And finally, direct the company to notify the Commission within 10 business days of when the Commission grants the waiver regarding whether the company accepts all of the conditions imposed by the Commission in connection with this waiver. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Chairman, if I may, I apologize. So I'd like to point out that staff's comments contain an affidavit from, I believe, Oh, I'm sorry. Staff's comments contain an affidavit. I believe I referred to him as Mr. Williams. Mr. Wright, I believe he's the Vice President of Operations. The affidavit included in staff's comments does not actually promise to use fingerprinting. So that is why OPC requested that the company refile an affidavit yesterday. And the affidavit filed yesterday, I'd just like to draw the Commission's attention to it, does involve all of the processes described today. So OPC would respectfully request, and maybe you've already considered this, but OPC would respectfully request that the company be ordered to implement the procedures additionally described in that affidavit filed yesterday.
That work for staff?
Staff has no objections.
Okay.
No objections.
All right, so we'll add that as part of the motion that the company follow the process in that affidavit. So. Okay.
The next item on today's agenda is from Sandpiper Energy, Inc. It's revised tariff pages for its annual system improvement rate and reconciliation.
Good morning again, Mr. Chair and Commissioners. Cameron Walton on behalf of staff. I'm joined by Mark Riley of the Accounting Division and John Clemenson of the Engineering Division via video chat. On November 1st, 2024, Sandpiper Energy, Inc., Sandpiper, filed revised tariff pages to update its system improvement rate, or surcharge, to be applicable for the 12-month billing period of December 1st, 2024 through November 30th, 2025. The filing proposes an increase to the current SUR of 0.502 cents per CCF 100 cubic feet of natural gas to 0.517 cents per therm of natural gas. However, for customers within the corporate limits of the town of Ocean City, Maryland, Ocean City, the filing proposes to increase the Ocean City SUR from the current 0.567 cents per CCF of natural gas to 0.576 cents per therm of natural gas. Sandpiper's energy service territory is in Worcester County. In 2013, the SUR mechanism was set up to enable Sandpiper to recover the cost of replacing bare steel mains and converting propane customers to gas. The SUR is composed of three costs: bare steel replacement, distribution system conversion, and inside the home conversion. The bare steel cost component includes the replacement of bare steel pipeline in order to improve the reliability of the natural gas distribution system. The distribution system conversion costs include the cost of converting propane distribution facilities to natural gas distribution facilities. Inside the home conversion costs include the conversion of customer-owned behind-the-meter piping and equipment from a propane system to a natural gas system. Sandpiper's annual SIR calculation accounts for those costs plus a reconciliation from the previous year. The SIR is calculated separately for Ocean City customers and non-Ocean City customers because there are additional costs related to the Ocean City which are paid by those customers, following the principle of cost causation. Sandpiper's 2024 SIR filing shows an increase in SIR rates for both OC and non-OC customers. For OC customers, the increase is approximately 1.6%, and for non-OC customers is approximately 3%. The company's total projected SIR revenue requirement is approximately 7.9% greater than the previous year. This is primarily driven by an increase in distribution system conversion and the true-up from the previous year. Staff's Accounting Investigation Division has determined that the new rates have been calculated accurately. Regarding the gas distribution system projects, the Engineering Division has performed a review of the bare steel replacement, distribution system conversion, and inside-the-home conversion projects included in the calculation of Sandpiper's SIR filing. Staff also requested additional data from the company during the review process. Based on the company's responses and documents reviewed, staff concludes that the projects found in the SIR filing were acceptable. Staff also discovered that the Sandpiper NGA replaced the bare steel pipe in its gas distribution system from 2017 to 2024, but had indicated 0 mileage of bare steel pipe in the gas distribution system in the Annual Pipeline and Hazardous Materials Administration, PHMSA. Staff recommends the Commission accept the tariff pages for the filing effective for the 12-month billing period of December 1st, 2024 through November 30th, 2025. Additionally, staff recommends that the Commission direct the company to file with the Commission the mileage and location of all bare steel pipes that are found and replaced for each year from 2017 to 2025. Thank you, and I'm available for any questions.
Any questions for staff?
I'm sorry, excuse me, sorry. We also replaced the staff, or I can leave it to Ruthie Herman.
Good morning, Commissioners. Ruthie Herman for staff. We also want to say for the record that staff withdraws the last statement that is in the recommended action in the buck sheet. So staff no longer recommends that last statement that begins. Staff also recommends the Commission require the company to correct its annual PHMSA report. And if you have questions about why it's withdrawn, John Clemenson is here. Thank you.
Well, actually, so why don't you go ahead, Mr. Clemenson, and explain to us why you're withdrawing that, so.
If I mute myself, that's because I'm having a coughing fit.
No, that's fine. No, you're fine, so.
Basically, when we originally put that recommendation in, we wanted the company to go and update their forms, because back in, I think it was 2017, they reported the fact that they didn't have any bare steel in the ground anymore. And they've been reporting that year after year after year. So when we found out that they had actually discovered some, unbeknownst to them, we felt that, that they should go back and update that data in the annual report, because PHMSA's kind of a stickler for getting the data right and correct. So at the time, we didn't think it was going to be that much work. Well, earlier this week, the company started reaching out to us and kind of indicated that, it's not that many miles of main, and it'd be a little bit of work to do what we're asking. So once I determined how much they had, which was roughly 1,842 feet of main, or 3.5 tenths of a mile, I indicated to the company I would reach out to PHMSA just to double check and see if they wanted them to update it. I reached out to PHMSA. They got back to us and they said for that small amounts, there's no need for the company to go ahead and update it. Based on that, therefore, we withdrew that recommendation.
Okay, thank you. So,
Morning, Mr. Chairman. Brian Quinn on behalf of Chesapeake Utilities. I'm joined by two representatives of the company to answer any questions you may have. We agree. Thank you for staff's buck sheet and their time on this. As Mr. Clemenson mentioned, we've been talking with them earlier this week, and we agree with their recommendation to file a report disclosing the length and location of bare steel replaced from 2017 through 2025. And I'm advised by the client we could get that report in by the end of next week.
okay. Any questions? Seeing none?
Mr. Chairman, just want to say happy opening day to Commissioner Barnabé.
Sorry.
I miss all the parties.
Yes, sir.
That's right, yeah. So I move we accept the tariff pages for the rate schedule SIR effective for the 12-month billing period of December 1, 2024 through November 30, 2025, and direct the company to file with the commission the mileage and location of all of the bare steel pipes that were found and replaced for each year from 2017 to 2025. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
The last item on today's agenda is from the Supplier Coalition. Its request to modify and clarify the Commission's December 17th, 2024 supplier license renewal notice.
Yeah. No, yeah. Oh, we're going to take it under advisement. Yeah. Right. Well, we'll see. So it's still.
Kevin Mosher on behalf of staff. On December 24th, the Supplier Coalition filed a notice to modify the Commission's December 17th supplier license renewal notice. Having reviewed the filing and the language in Senate Bill 1, staff recommends that the Commission determine that the renewal process only apply to suppliers that are licensed to offer residential service, that the initial expiration date be moved to no later than March 31st, and that the renewal applications be filed no later than March 15th.
Okay. So any questions for staff? So let me ask one. I mean, I do remember the discussion during the legislative process about, the commercial guys were happy and didn't need any extra protection. The companies that offer retail energy services, do they fall into two separate pots, or are there companies that offer both commercial and residential services?
I would say 80% of customer or of suppliers have a license to offer, commercial, residential, industrial. Probably about, 10 to 15% are just C&I only, and maybe 5% are just residential. But yeah, the vast majority they check off every box.
Okay.
Now, they may not be serving all classes,
Right.
but and even there, I think, well, particularly if we're talking suppliers and not brokers, I think most suppliers offer all classes.
Okay, so the only people that wouldn't have to file for renewal are those that only offer commercial.
Correct.
Yeah, okay.
Yeah, I think even if they're not serving residential customers, if they're licensed
to do it, yeah.
I think they would
Okay.
still need to.
Okay, all right. OPC.
Thank you, Chair and Commissioners. Milan Tekle-Mikhail on behalf of the Maryland Office of People's Counsel. OPC does not oppose the Retail Supplier Coalition's joint request, but we also support staff's recommendation as to when the initial expiration date should be and as to the deadline for the application for renewal. And we also agree that clear guidance is essential to ensure that all parties understand the process and that notices are issued appropriately based on compliance with the stated deadlines. Thank you, and I'm available for questioning.
Any questions for OPC? Sure.
So, just to be clear, you're supportive of staff's recommendations?
Correct.
Okay.
Anybody else? No, Commissioner.
Yeah, could I just ask just a process, and maybe for OPC and staff? So if there's a company that's serving all classes of customer, would the process be such if they were going to then move to just supplying commercial industrial, that they would reapply to do that in this process of revocation?
Actually, I think they just need to make a simple filing saying that, we do not serve residential customers, and we would like to have our authority to serve residential customers withdrawn.
So it would just be a change of the license then to
Correct.
just commercial industrial.
Right. I think it'd be much like, if they entered a new service territory, just a simple, just a short letter describing what they're doing.
And they could do that at any time at this point
Absolutely.
and avoid some of this.
Yes.
Okay, terrific. Thank you.
Well, this is a follow-up to Commissioner Richards' question. Would we then have to take action on that, or would they just sort of let you know and then?
I believe you'd have to take action.
Okay, so we would have to go through a whole process of, approving their not offering or limiting their service to commercials, right?
I think so. I mean, you could sort of potentially delegate this. We've done something similar in telco years ago where, staff would work with the executive secretary's office and just, send out letters where it wouldn't necessarily go to an admin
Sure.
meeting if you wanted.
And I take it this would be a one-time thing, right?
Yeah, I think that's my, yeah.
Yeah. Okay.
Excuse me.
Okay, so let me turn to the
Yes.
retail.
I'm sorry. I
Well,
just wanted to-
anything else from?
Yes, I just wanted to add on to that point. Technically, as OPC envisions it, it will be a relinquishment of a license to supply supply services to customers. In which case, we would recommend that this be brought in front of the commission and commission approve it. In case there are complaints that are unresolved, that the commission should be made aware of, or any outstanding assessments that the companies have not. Met their obligations. So it technically would be a relinquishment of their ability to service residential, even if they're still maintaining their commercial industrial licenses.
But what about its hypothetical where, they have a license to offer to residential customers, but for their own purposes, they've never signed up a residential customer.
In that case, we would envision it shouldn't be any problem to go through the process and report as such, and it would be basically a swift process that staff would note. There's an application that they have to submit, and staff reviews whether there are any complaints against them, whether here or in other states. And I think as far as the commission having information on hand, it would be more beneficial to go through a process that has already been established instead of creating a new process that has certain uncertainties and might create a gap in information.
I understand, but I guess I'm a little concerned about, I don't want to say clogging up, but if we have, going through the motion of adopting these things for somebody who's, never done this and never had anybody, I guess I'm contemplating how we might be able to delegate some of that authority to staff to eliminate, sort of everybody coming in here and basically going through
In which case, we would recommend that maybe, staff and other parties come together to discuss what that looks like under the SB1 mechanism in order to determine what that process looks like.
I was going to say, I think my suggestion would be, if the commission is okay with this, again, staff can work with the executive secretary's office. If we see a company that has never served residential customers, doesn't have customers, there are no CAD complaints, maybe we could do that sort of a more informal process. But if there were even such as a single complaint, then we would maybe.
Yeah, no, I'm only thinking about the folks that, for whatever reason, when they signed up years ago, decided to check all the boxes, but for their own purposes have never gone into that area. I'm thinking that, we don't necessarily have to go through a whole lot of administrative churn to make this happen, so.
And I think there are, maybe not as many suppliers, but I think there are a lot of brokers that are in that because again, it's.
No, I'm sure,
I think almost everyone checks all the boxes because, you'd rather err on the side of cost.
Yeah. Okay. So let me turn to the retail supply folks.
Yeah, good morning, Chairman, Commissioners. Eric Wallace on behalf of the Supplier Coalition. We appreciate staff and OPC's comments and their quick attention to this, given the timing concerns that we raised in the request. I think all the parties want to figure out the most reasonable path forward here to be efficient and make sure that a third of the license renewals are done by June 30th. We don't oppose staff's recommended timing. In the Supplier Coalition request, we had suggested doing a 30-day, in advance of your renewal date, deadline for filing, modeled off of what's done in New Jersey. The sequence there, I think, is based on when you initially filed your application. So we're in a little bit of a different posture here, where this is a new requirement that's, where the commission is sort of administratively setting those dates rather than tying it to the initial applications. And so I think our preference would be to continue with that going forward in the long term. I think that's the most efficient way to do it. But if the commission is inclined to take a different approach for this initial 2025 tranche of projects coming through, I think the key thing is we wanted to get a little bit more time given the holidays and some of the concerns we raised in the filing. One timing consideration that we had in reviewing staff's buck sheet was, if all of the applications are due March 15th, and, we had suggested bumping the expiration dates out towards the end of April, being the first one, and staff had suggested keeping March 31st. If somebody's filing an application on March 14th, it doesn't seem like there's enough time for that to get reviewed by staff and to appear on an admin by the 31st, or at least that's going to be really tight. So we just, ultimately want to make sure there's sufficient time here for staff to do the review that it needs to do. If there may be some discovery requests or issues that need to be discussed between staff and the applicant in advance of the administrative meeting where this is heard, we want to make sure there's enough time to do that. And what we don't want to bump into is on the back end, having somebody who's scheduled for March 31st, and there's some sort of a delay, and then they need to come in and request an extension, and it adds more administrative process to it. So, we just want to, we appreciate staff's recommendation to add additional time, and our primary position is sort of our tiered approach based on the revised schedule and the chart we included in our filing. But if the commission's inclined to do March 15th across the board deadline, we're okay with that. We just want to make sure that there's enough time. Maybe recommend bumping back that initial deadline so that those can be reviewed. And with that, happy to answer any questions.
So, any questions? So, any reaction to his helpful suggestions?
Yeah, I think we're not opposed to bumping back the March 31st date. At the end of the day, we're kind of guessing here. We've never done this process, and we want to make sure that both staff and the commission has time to review what, maybe as many as 200 renewal applications between now and June. And I think bumping it back by, a little bit is probably okay. I mean, I think the March 15th date we definitely want so that we can start processing them and reviewing them. The actual first date for, I think we're okay with changing that. Again, it's, we're kind of guessing here as to how much time we'll need for a process none of us have done.
Okay.
And Chairman and Commissioners.
Okay, so I wonder if we can get a commitment for a certain amount of time for bumping it back. So you're concerned about there being a 2-week period for them to review the applications. That's not going to be enough time. Would 30 days be enough?
We think that 30 days is what we see in New Jersey. It's sort of a reasonable minimum. We wouldn't want to go with any less than that if the commission.
Okay, so could we do April 15th, which people probably have other commitments on that day as well. But would that work for an OPC? Would April 15th work? I mean, as long as if we can get a commitment here, that sort of makes it easier to move forward.
Yeah, staff is okay with that.
Okay.
Yeah, and there was a couple other points I wanted to raise just before we conclude this discussion. In reviewing the notice and the materials, there were some additional sort of process questions that my clients had raised. One is certainly, commercial customers, and we had that discussion with staff a few moments ago. And we don't think that this renewal requirement should apply to the exclusively commercial folks. They will be filing annual updates, just as they do now under the Commission's existing regulations. So the Commission will have ongoing oversight of what's happening with them and any changes that may happen there. In addition, there's some questions about, are, suppliers that are licensed exclusively as a broker treated the same way as a marketer that is taking title and supplying electricity? It appears that's the case, but, we wanted to raise that question and make sure we're clear so that, folks that the Commission is expecting to apply are getting those in on time and understanding the requirement. There's also a question around dual fuel suppliers. So some suppliers will serve both electricity and natural gas and would have applied for both commodities with licenses in order to get licensed to do so. And so would they file a single license application for both commodities, a renewal application, or would they file two, one for each commodity? And along with that, there's an application fee of $1,000 per application. So understanding whether the Commission is expecting a separate application for each commodity or just one application per entity is another question that has come up from the Supplier Coalition. So we ask for the Commission's direction on that as well.
Well, in reference to the last one, what do you currently do?
Currently, when a supplier comes in, they have separate. There's an electricity application and there's a natural gas application. So there's two separate applications. The license renewal application that was included in the notice is sort of not specific to a commodity. So that begged the question of whether the commission was, intending to kind of streamline things with a single application or require commodity-specific applications as the existing initial license application structure is set up.
Okay, so
I think staff's view is that the renewal is for each individual license number. However, if the commission determined that it's, a company doing electric and gas can just use the same form one time, I don't think staff has no objections to that. I can't think of any real drawbacks. It might in fact be a little easier. I will say, our renewal fee of $1,000 was picked specifically based on kind of the number of total licensed applicants out there, and the fact that SB1 specifically required those fees to pay for 2 investigative positions. So if you do decide to, it kind of changes those numbers a bit. But other than that, I can't think of any drawbacks of just requiring one application renewal for both.
and what about the other concerns he had?
Regarding the brokers?
Yeah, right.
Yeah, I think this certainly, I think SB1 is pretty clear that if a broker is serving residential customers or even has a license, then they would need to come in for renewal as well. Yeah, the statute, I think, is very clear that brokers are suppliers.
Okay. All right. All right, so we actually are going to take this under advisement, and we'll be issuing something in writing relatively soon to try and clear up all this based on what we've heard from everybody today. So with that, we're adjourned. Thank you.